Torts Bulletin for today. So today, we will delve into the topic of contributory negligence with me, Izhanin Christina binti Muhammad Izzuddin, 2418620.
Assalamualaikum, my name is Afifah Najwa binti Tarmizi. My matric number is 2414136.
Hi, my name is Nurul Aizafah binti Zakaria and my matric number 241630.
So in our topic today, for contributory negligence, we will delve into the case of Kuala Terengganu Specialist Hospital Sendirian Berhad and another against Ahmad Thaqif Amzah bin Ahmad Huzairi, which is claiming through mother and her litigation representative Majdah binti Muhammad Yusuf and other appeals 2023. So this case was decided at the Court of Appeal Putrajaya by Judge Gunalan Muniandi. So the parties involved in this case, the appellant is Ahmad Thaqif Amzah bin Ahmad Huzairi and the respondent is Kuala Terengganu Specialist Hospital Sendirian Berhad. This judgment was decided on 27 September 2022. So before I go deep into the topic, into the case of Kuala Terengganu Specialist Hospital against Ahmad Thaqif Amzah, we will first define contributory negligence. Contributory negligence, it is a common law tort rule that bars plaintiff from recovering damages for the negligence of others if they were also negligent in causing the harm. So this doctrine has been replaced in many jurisdictions with the doctrine of comparative negligence. So in tort law, a plaintiff, they can recover against a negligence defendant by proving three elements. The first element is that the defendant must owe a duty to the plaintiff. Second element is that defendant breached that duty, and third, due to the breach of duty, the plaintiff suffered harm. So in jurisdiction that follows contributory negligence, a plaintiff who is even slightly negligent cannot recover damages even if they has established all of the elements. Therefore, the degree of the plaintiff or defendant's respective negligence is irrelevant. Thus, a plaintiff who was 1% negligent will receive nothing from a defendant who was 99% negligent. However, this has been improved as the outcome of this, as society deems that this outcome is inequitable. So due to the strict nature of contributory negligence, courts has developed exception over the years. For example, under the doctrine of last clear chance, a negligent plaintiff can still recover if the defendant was the only party capable of preventing the harm through reasonable means and failed to do so.
Now, let's move on to the facts of the case. The respondent initially consulted Dr. Zainal at Kuala Terengganu Specialist Hospital complaining of respondent's high temperature and neck swelling. Dr. Zainal then gave medicine and let the respondent go home. 2 days later, the respondent returned with fever and increasing neck swelling. Dr. Zainal advised them for immediate assessments by specialists. However, the respondent's parents refused to admit the respondent to specialists. Only 5 days later, the mother took him to a private clinic where the doctor urged him to be promptly taken to Hospital Sultanah Nur Zahirah. The next day, the respondent underwent surgery at Hospital Sultanah Nur Zahirah to remove a large abscess in his neck that was preventing him from breathing properly. Despite being placed on a ventilator during surgery, the respondent's brain had already suffered permanent damage due to acute oxygen deprivation, resulting in mental and physical problems. The mother, as the representative of the respondent, brought claim against the appellant, contended that the appellant is negligent in failing to diagnose and promptly treat a growing swelling in his neck.
See you in court.
As we have gone through the background of the case, now it's time for us to determine the legal issues.
So the first legal issue, whether finding of contributory negligence was valid despite the parents not being parties to the action and the infant in himself being an innocent party. Second, whether respondent's parent was substantially liable in contributory negligence for the delay of seeking medical treatment for the respondent despite negligence of the doctors to inform the seriousness of his condition and the need for urgent treatment.
Next, we move on to the details of the case. First of all, we will be discussing the appellant's argument. Your Honor, we the appellant submit that the parents had not responded to the averment and plead that they could not be held liable because they were not parties to the action, even though we had explicitly stated in the pleadings that the respondent's parents is contributory negligence for the delay of the treatment of the respondent. They had ample time to address the issue of contributory negligence, but they never did. Additionally, even though they were not parties to the action, they were fully responsible for managing the plaintiff's care at all relevant times, including making the decisions regarding when and where he should be admitted for the treatment suggested by the doctor. Furthermore, the parents is contributory negligence for the delay in taking the plaintiff for proper medical treatment after Dr. Zainal has advised to admit him to the hospital, and the delay of 5 days has contributed to the worsening of the plaintiff's condition. And moreover, excuse of financial constraint was unreasonable and devoid of merits. It was the responsibility for the parents to take the steps to bring the infant urgently to the public hospital due to the seriousness of his condition. And that's from us. Thank you, Your Honor.
I'm on the behalf of the respondent Muhammad Takif. Yang Honor, we, the respondent, submit that the finding of contributory negligence was fundamentally flawed. Why? Because the respondent's parents were not parties to this action, as well as an innocent infant, Muhammad Takif, should not bear any apportionment of liability or contributory negligence. Furthermore, no medical witnesses testified that the parents were to blame for the plaintiff's injury. The alleged delay in seeking medical attention was due to the financial constraints, a challenge that the parents faced under difficult circumstances. Additionally, there is likely a change of causation regarding the injury. When the respondent was admitted to the hospital Sultanah Nur Zahira, he was still breathing normally and only collapsed several hours after the collisions. So the appellants also failed in their duty to properly advise to the respondent's parents about the urgency to refer to the hospital Sultanah Nur Zahira for the treatment. They also not provided sufficient evidence to prove that the alleged delay directly caused or materially contributed to the brain injury. So for these reasons, we maintain that the finding of contributory negligence cannot stand. Thank you.
Next, we move on to the judgment of the case. First of all, the judge found on the whether finding of contributory negligence was valid despite the parents not being parties to the action and the infant himself being the innocent party. This issue was raised by the respondent, which was not raised in the trial court. So the court held that in principle and authority, the respondent is not allowed in appeal stage to raise a fresh issue that was neither canvassed and litigated nor adjudicated by the trial court because it was unpleaded. The respondent had initiated his claim through his mother as the litigation representative. Thus, the mother is indirectly a party to the proceeding. Also, the parents had the responsibility to manage for all matters relating to the treatment of the respondent at the hospitals around the time of the incident.
So the second issue, the parents were liable for contributory negligence to the extent of 30%, principally due to their unacceptable delay in bringing the respondent to Hospital Sultanah Nur Zahira. So the court found the respondent's argument on financial constraint to bring the infant to the hospital was actually unreasonable out of the awareness on free medical treatment provided in Hospital Sultanah Nur Zahira. So next, the fact that the respondent breathing was in a good condition at the time he was admitted to the Hospital Sultanah Nur Zahira did not break the change of causation. During 5 days of the delay, the plaintiff's neck became bigger. The court considered that if the parents had brought the plaintiff to Hospital Sultanah Nur Zahira earlier, the severity of his condition could have been avoided or substantially mitigated. So the appellant had failed to prove that the delay on the respondent's part had materially contributed to the respondent's brain damage. So therefore, the appellate court upheld the trial court's decision, affirming that the parent's delay was actually unacceptable and had partly contributed to the respondent's injury.
Guys, I think I found 5 ratio decidendi from the judgment. First thing first, plaintiffs can be held partially liable for injuries because of their own unreasonable actions or omissions that partially contributed to the harm. Plaintiffs have a duty to act reasonably and promptly in addressing medical needs and acting on the medical advice, and failure to fulfill this duty can constitute contributory negligence. The second one is
The second one is a delay in obtaining timely medical attention can be considered as contributory negligence if it exhibits an injury or worsened condition. The chain of causation remains unbroken if the delay directly worsens the harm. And thirdly,
Damages can be reduced if a person is found to be contributing to their own injury. In the case, the parents' delay in seeking medical treatment for their children for the respondent was deemed negligent and led to the reduction in the recoverable damages by 30%.
lastly, when a claim is brought by an infant through a legal representative, the representative action can be scrutinized for contributory negligence as they are responsible for managing the infant's well-being at the time of the incidents. For an appeal against the decisions of a trial court, parties were not allowed to raise new issues that were never canvassed during proceedings in the trial.
based on the ratio decidendi we have stated earlier. We agreed with the decision made by the appeal court because the judgment given is just, fair and reasonable, as well as the damages recoverable for the plaintiff was sufficient and equitable. In this appeal court, the court had adequately considered the material facts and evidence as a whole before making an affirmative finding that the parents' failure to act promptly to the advice to have the infant warded at Kuala Terengganu Specialist Hospital, followed by the 5-day referral to Hospital Sultanah Nur Zahira, had partly contributed to his eventual permanent injury. Have you heard of this case? The recent case when Suzilawati binti Ali and another and Dr. Alif.
Oh yes, I heard that case which decided on the issue of causing child death by going against medical advice.
That one case, the parents they transferred the child to another hospital which is against the doctor's advice, despite the child's precarious condition. In this case, the defendant had sufficiently given advice of urgency to make choice of transferring the deceased to either two of hospitals and carry out examinations to the plaintiff. However, the plaintiffs were then decided to transfer to PPUM, which is Pusat Perubatan Universiti Malaya, which is against medical advice, even though they were well aware that deceased oxygen level is failing.
Because of this unreasonable and rash conduct which contributed largely to the disease death, the court found that the plaintiff to be 60% contributing negligent, while the third to the 16 defendants were 40% negligence. All awards of damages to the plaintiff were subject to 60% deduction for contributing negligence. As in this case, the parents of the respondent was held contributory negligent for the delay of seeking medical treatment to the hospital, which is against what has been sufficiently advised by the appellant. Thus, the damage recoverable was reduced to 30%.
Hence, we strongly believe that the same ruling should continue to be practiced. This is because only in this way justice could be served by distributing the liability proportionately to the responsibilities towards all the parties negligent in the case. Given that the Kuala Terengganu Specialist Hospital and Hospital Sultanah Nur Zahirah is liable for medical negligence, instead strictly imposing the appellant to pay for the full amount of damage, the court could reduce the damages payable, considering that the parents' failure to follow urgent advice was a part of the factor of the injury.
So for our next case, do you know the case of Pigeon against Doncaster Health Authority 2022?
Yes, I know that case. This case involved a cervical smear test in 1988 that was wrongly evaluated and caused the claimant's cervical smear test to be negligently reported as negative. The claimant was repeatedly urged by her general practitioner to have further smear tests, but she refused to do so and ignored letter from the screening program because she found the procedure was painful and embarrassing.
And I believe that in 1997, she was found to have cervical carcinoma. She contended that there was a breach of duty by the health authority in relation to the 1988 smear test that was negligently evaluated. The court held that the health authority was liable for negligent evaluation of a cervical smear test which failed to precancerous condition.
So the court found that although the patient conduct did not break the chain of causation, she is responsible for her injury as she failed to attend screenings in the following 9 years, and thus she was entitled only to 1/3 of the excess damages.
So in this well-decided case, damages can be reduced if the claimant's action contributed to its own injury, and the court assesses the extent to which the claimant's conduct affected the outcome and apportions liability accordingly.
In relation with this scenario, the court has effectively applied the principles in whereby it was found the respondent's delay partially contributed to her injury. The fact that plaintiff is still breathing normally after the unreasonable delay and before the admission of surgery to Hospital Sultanah Nur Zahirah had not break the chain of causation between the unreasonable delay and the respondent's worsening condition of brain damage.
Given that the respondent has contributed to his own injury, the judge ensured fairness on both the appellant and the respondent by reducing the amount of damages awarded to the extent of which the respondent's delay has caused the injury. And for our Malaysia recent cases regarding contributory negligence, we are referring to the case of Muhammad Afzan Alwi bin Muhammad Fazli Ahmad. So this case, it involved a motorcycle and motorcar accident on 21 September 2019 when plaintiff was travelling on his motorcycle. He saw defendant's motorcar exited out of the minor road at Poblacion. So defendant, he had crossed plaintiff's rights of way who was travelling at that time straight on the main road. So when the defendants crossed plaintiff's way, it resulted in collision between plaintiff's motorcycle and defendant's car. And plaintiff persuaded court to pronounce 100% liability on defendant, whereas defendant demanded the liability to be reduced to 50%. So the High Court made the following observation of contributory negligence, which does not mean that claimant commits a breach of duty towards defendant. It means that the claimant failed to use reasonable care for his safety and so contributed for his own damages. So taking the totality of evidence in this case, plaintiff told his court that he first saw defendant stop about 50 meters away from his position. Then he mentioned that defendant exited when plaintiff was 15 meters away from his car. So it is reasonable to expect the plaintiff to slow down his motorcycle the moment he saw defendant's car exiting out of that junction. So the court found that 15 meters was a very reasonable distance that should give plaintiff sufficient opportunity to react if the motorcycle was ridden at a low speed. So plaintiff might have ridden his motorcycle at a considerable speed which prevented him from reducing the speed of his motorcycle in a short time. Otherwise, he would have been able to avert the collision or at least mitigate his losses. So based on that, it was decided that plaintiff was contributory negligent and the award should be recovered shall be reduced by 20%.
In relation to the case of Kuala Terengganu Specialist Hospital and Ahmad Takif, the court had successfully applied the principle of claimant failing to use reasonable care for his own safety and so contributed to his own damages. Claimant in this case is Ahmad Takif, claiming through his mother. As the court had answered whether a finding of contributory negligence was valid despite the parents not being parties to the action and the infant himself being an innocent party, we shall move to the applied principle. His parents has failed to use their reasonable care as a parents for their own child's safety and therefore contributed to the plaintiff's brain damage. It was unreasonable on the part of the plaintiff's parents for their tardiness to bring him to Hospital Sultanah Nur Zahira. His persistent fever and the increasing size of the swelling on the plaintiff's neck should have been a cause of concern for the parents to take an active step into bringing the plaintiff to a government hospital for further examination promptly. Therefore, it was found that the plaintiff's parents were 30% contributory negligence.
That's all from us. Thank you.
Next, we also agreed to the decision of the court on the finding of the contributory negligence was valid despite the parents not being the parties to the action and the infant himself being an innocent party. This is a new issue raised by the respondent on the appeal court but was not raised earlier in the trial court. The appeal court held that the respondent held that under the principle of the respondent is not allowed in the appeal court to raise a fresh issue that was neither litigated nor adjudicated by the trial court. This judgment aligns with the case of Notting Hill Finance Limited and Sheikh. The case provided an important guidance on the principles to be applied when considering whether a new point not raised in the court below can be taken on appeal. So, in this case, on appeal, the Notting Hill Finance Limited argued that Sheikh should not be permitted to raise these new arguments on appeal as they had not been raised at the first hearing. In this English case, the court laid down legal principles in which an appeal court will always be cautious before allowing a new point to be taken on the appeal stage. The decision whether it is just to permit the new point will depend upon an analysis of all relevant factors, particularly the nature of the proceedings which have taken place in the lower court, the nature of the new point, and any prejudice that would be caused to the opposing party if the new point is to be taken in. Thus, in relation to our case, the court upholds the precedent and the principle of law that parties are bound by their pleadings and cannot introduce new issues on the appeal. This emphasizes that allowing new issues would be unfair to the other party and would undermine the judicial process.
So for the last thing, what about the impact on future cases from the case of Kuala Terengganu Specialist Hospital Sendirian Berhad and another against Ahmad Takif Amza bin Ahmad Huzari? So it is anticipated that court will determine that any defendant that succeed to plead all the essential element of contributory negligence to the plaintiff, such as foreseeability of harm, standard of care and causation, can reduce the amount recoverable by a plaintiff comparatively. So from this case, we have found that the impact towards future cases is that it could reduce the amount of fatal casualties due to parents' negligence towards a child. In this case, it allowed pleas on contributory negligence from defendant to plaintiff and has established a principle that parents may be partially responsible for acts of medical negligence toward their children. In the future, this case may influence, or this case might be the precedent of how courts assess contributory negligence in medical negligence claim. Healthcare provider also may be more vigilant in ensuring timely and adequate care to avoid liability. Additionally, plaintiff and their representative may need to be more aware of their action and how they could affect the outcome of their claims. So this case, it sets a precedent for balancing the responsibilities of both healthcare providers and patient, potentially leading to more equitable outcomes in medical negligence cases.